Yeah, so I'm gonna go straight into it. Boilerplate clauses. Basically, what boilerplate clauses are, they're standard miscellaneous clauses that are contained in most commercial contracts, and they basically detail things or spell out things like the allocation of risk in a contract, the indemnification of a specific party or parties to the contract, the assignments of rights or cession of rights in a contract. Another thing could be how disputes are resolved, right? There are many miscellaneous clauses in a contract, and I won't go about spelling out all of them, but some of the few that I would like to talk about is ones that we commonly deal with in most contracts, but we do not pay close attention to them because it looks straightforward and standard. So the first clause that I'm going to be talking about is the breach clause, right? So the breach clause is very important because it kind of gives you the instructions on how you can terminate the contract. Right. So I'll give you a quick scenario. So if A hires B to provide a certain product or service, right? And by, let's say, Wednesday, and now it's today is Thursday, and B still hasn't provided the certain product or service, then B is now in breach, right? So what people tend to do, people that do not understand the breach clause, is that they'll hire C to do what B was supposed to do, and then they'll tell B that, listen, you were supposed to do this job by Wednesday and you did not do it, so that's why I hired C to do that job, so just leave me with that mess and don't argue with me. But then B has a valid claim against A for also breaching the contract in that he did not properly terminate the agreement. And generally, what a breach clause or termination clause will contain is just details on how you can terminate the contract. Example being that in the event of a breach, meaning that you're supposed to deliver a service or product at a certain time and it wasn't delivered at that time, um, the party that's affected by the breach can then inform the party that's in breach in writing that there is a breach and I'm notifying you of this breach and I'm giving you, let's say, 5 to 10 days to remedy that breach. And then in the event that B still hasn't delivered the goods and services in the 5 to 10 days that have been allocated by A, then A can then terminate the contract with B in writing and then allow C to then come in. Right? It's a little confusing, but if you listen to this again, it'll kind of make sense. You know, it's just provisions to make sure how you can terminate a contract and then hire someone else to do that specific task that you hired B to do. Another common provision is force majeure. Force majeure, is basically an event or an occurrence that happens that it's out of your control. And an example of this is like if I've been hired to paint the road and then there's a flood, right? So I've been hired and I've given instructions that on Wednesday I'm supposed to paint the road, and then there's a flood on Wednesday, flood on Thursday, and then now I'm in breach of contract, right? Because this was the date that I was supposed to perform the task, and on this date it was physically impossible for me to think because you can't paint on a flooded road, right? Then this product provision or clause then comes into effect where a party can invoke force majeure and say that, listen, I'm well aware of the fact that I'm in breach, but this breach happened because of an event that was out of my control. There was no way that the party could stop the flood. There was no way that the party could perform the task with the flood. So that's why the invokement of force majeure then happened. Another clause that's very important in contracts is dispute resolution. And basically, what dispute resolution is about is that it gives you a method of resolving the disputes, any dispute that may occur during the agreements or the contract period before it's going to court. So an example being is that what you would usually find in dispute resolution clause is that if there's a dispute, right, between the two parties or the parties involved, then instead of going to court or suing that person, they first have to go through mediation or arbitration before they can go to court, right? And this kind of protects parties from constantly going to courts for every little petty thing and whatnot, because sometimes things happen because of miscommunication. So before a matter can go to court, it needs to go through mediation or arbitration. Usually a person that's competent enough to understand the agreements is appointed to do this mediation and arbitration. And yeah, and so it's basically a method of resolving a dispute prior to going to court. That's the best way I can explain it. The next clause that I'd like to speak about is the assignment or cession of rights, right? And what will happen is that, let's say I owe A money, right? And so I've been paying A, I've been paying A, I've been paying A, and then in comes B and says that, listen, instead of paying me the money that you owe, can you cede me the rights that you have? Basically, a debtor's book. And then what will happen is that A will then cede their rights to B, right? And then me, as a debtor of A, will then have to pay B instead of A, because A has ceded his right to B, right? And that's another thing, is that people don't like that whole seeding thing. And what will happen is that instead of me performing a specific task that I've hired to do, I can then cede that right to someone else and say that, listen, I'm hiring you to do what I was supposed to do, instead of me doing it myself. So sometimes contracts will usually say that, no, if I hire Taban and Gisela, I want Taban and Gisela to do the work. So there's no cession or assignments of rights. And sometimes they'll say that, listen, if you can find a competent person or whatever to do that, then the rights that you have can be assigned or whatnot. The cession and assignments of rights goes much deeper, and I'm not going to get into that right now. But yeah, that's typically what it is. So yeah, the last clause that I want to talk about is the non-variation or the amendment clause. And basically what a non-variation clause is that if a contract details has certain terms on it, and for whatever reason we decide that, listen, we have to change the terms of the contract, right? And both parties agree to that. The non-variation clause will then give guidance onto how the contract can be amended. So instead of drafting a whole new contract, you just want to amend one clause. It'll probably say that both parties need to sign to the amendment and agree to the amendments in writing, and only then can the amendment can be effected. And it also probably give the period and time, whatnot, and other complicated commercial contracts go into more detail. But basically, that what it is. It gives the provisions of guidance as to how a contract can be amended, right? There's other provisions that I'd like to just mention that I will not discuss, because of the length of this YouTube video. But yeah, other provisions could be, but are not limited to, governing law that determines the law that governs the contract, waivers, indemnity, what I talked about in the intro, severability, another clause, very important clause that's needed in most commercial contracts, and then domicilium, uh, which is another clause that our learned folk would know about more. But yeah, maybe in another video I think I'll discuss these clauses in more detail. But I feel like there's just these five clauses that I just mentioned were just clauses that I feel like are very important and are overlooked in a lot of commercial contracts, and I feel like there's some light that just needs to be shed on them.